You're listening to the Valley Current.
So why don't you cover this last case that we're going to cover tonight?
Yes, and I thought it was interesting in that there were three issues in the case. First, whether they was standing. Second, whether the Department of Education was ultra vires. And third, if you want to get into it, Amy Barrett's little concurrence on the major question doctrine. And what's interesting about standing and ultra vires is, in a sense, they're tied together.
Yeah, we're talking about Biden's, I guess, executive decision, or
It was not the Department of Education that decided to, quote, to modify student loans by abolishing them, by waiving them. And the question is whether this is ultra vires, but the first question is whether they're standing to challenge this. So standing means that the plaintiff is harmed in some way by the decision. And the argument is no one is harmed. Okay, the students are benefited, they get more money. No one is really the worse for it. The national debt increases, but general harms like the national debt increases or the government is less efficient are not individual justiciable questions, nor should they be, because if they were, any political decision would be relitigated in the courts. So the standing doctrine is a good doctrine. Okay, on the one hand. On the other hand, let's say the government, as opposed to waiving these $10,000 pieces of student indebtedness, just decided to cut checks and give $10,000 to everybody who's 21 so they get off to a good start. That may be a good idea, but there's no statutory authority to do that. But the government says, what the hell, we'll do it anyway, because no one has standing to object. Again, the students are better off. The national debt increases, but that's a generalized harm. So no one can complain. So let's do it. And I knew that that could not stand. I knew that they could not get away with that.
Well, during the pandemic, which I think is just barely over, although some people claim it ended over a year ago.
According to the federal government, it is, though.
Right. We had this,
which is kind of a crucial fact.
We had this ton of money dropped on employers called, I think it's called PDP, which was designed to say, please keep people on the payroll and we'll more or less fund or help you fund your payroll during the pandemic period. And that was like a drop of money, or a pretty sizable dump of money that did get challenged and did get viewed as was within Congress's right to do it. Now here, Congress gave an authorization, but I don't think they gave an authorization to do a debt forgiveness of this magnitude. I think they gave an authorization to
modify the terms.
Yeah. Modified terms would be like extend the loan.
Yes.
Yeah. Change the payment amount.
In fact, the loans were extended for as long as the national emergency existed. Okay. So in terms of the timeline, we had this standing, sorry for using the word standing, we had this ongoing deferment of repayment. At a certain time, the Department of Education said, never mind, when the emergency is over, which is still in the future, when it's over, we will then waive repayment. Then time B, the national emergency was declared over, right? But then at time C, the waiver was supposed to take effect. So question, is that kosher? In other words, if the Department of Education was serious about staying within the terms of the emergency, then when B happened, when the emergency is declared over, they would rescind the repayment forgiveness because the emergency is now over. By not rescinding it, they kind of told me, at least, that the emergency was just a pretext. They wanted loan forgiveness, whether there was statutory authority or not. Do you agree with me?
Yeah, no, I agree. And I think that's the problem with the manner in which all of this occurred. And ultimately, the bigger picture question is the power of agencies to do things that are not explicitly delegated to them in the broadest language of delegation that can exist. And this is something that's sometimes called by Gorsuch in particular, the administrative state, the view that too many decisions are getting made administratively by people who are not elected officials. They're basically bureaucrats or technocrats or whatever type of crack you want to call them, engaged in the process of making decisions that are consistent with what the administration wants, presumably, but not necessarily consistent with what Congress actually authorized.
Exactly.
It's like a board of directors. Board of directors typically delegates, and this varies by state. Delaware does it one way, other states do it another. But basically, the power to execute various decisions is delegated to the CEO and the C-suite team, and typically the CEO has got the ultimate say. And the board is in more or less of a review function about what happens. Now, the board can tighten that authority and say, you're entitled to do X, Y, and Z, but you can't do, X prime, Y prime, or Z prime. And if the president or CEO go outside those boundaries, then there's an argument that the act was not really authorized. Now, there's all sorts of other principles that can make the act binding on the corporation in any event, but the board should have the ultimate say at controlling or choosing not to control its executives. And you could say that the board is like Congress. Congress has a bunch of people. They're much bigger than a board of directors. They vote, they pass rules and legislation, or they pass legislation. The legislation gets turned into various rules and regulations, hopefully consistent with the body of law that's been created, and then it gets executed. Now, if along the way, the wording is about modifying as opposed to rewriting, like you can modify this contract, and you can modify terms, but you can't rewrite it and you can't rescind it. And you can't just, something that's so beyond what power we gave you, kind of like a CEO saying, I'm just going to sell the business and all of its assets, and I'm going to merge it into something else. That's a board level decision. CEO doesn't get to make that decision without board and then ultimately shareholder approval. So there's certain things that can be done, certain things that can't be done. And to my way of thinking, this case of the three that we're talking about actually is the easiest to understand. Although you could argue that maybe it wasn't something that the Supreme Court should have taken, because it almost seems as though it's something that all of the courts of appeal should have agreed upon, and there really shouldn't be any disagreement about the power of Congress to delegate.
Well, let me ask you exactly that question. Okay, so basically the loan forgiveness was purportedly about COVID. Now COVID is coming to an end. Okay, yet the administration wants to forgive the loans. Why did the administration not simply go to Congress and say, in one guise or other, we think the loan should be forgiven? So what's the answer? Why didn't they go to Congress? The answer is because nothing can get through Congress.
Right.
Okay?
Right.
The Republican House and the Democratic Senate and the 60-vote filibuster, no, it would never get through. It wouldn't.
Right.
And so the court is taking on itself the legislative function of ruling on the extension of the loan, because the legislature can't do it. Kagan, in her dissent, says, okay, court, you're just taking over for the legislature. That's correct. That's just what they're doing. Robertson, his majority opinion, says the administration is taking over from the legislature the power of the purse, and they can't do that. And that's true as well.
Right. So
in the default of Congress, the Supreme Court on the one side and the executive on the other are rushing to fill that power vacuum because somebody has to, and Congress can't.
Right. So you could argue that the dysfunction in the nation is producing a dysfunction in Congress, which is producing a dysfunction in the executive, and it's producing a dysfunction ultimately in the Supreme Court. It's almost like
Yeah.
we're almost at the point of saying it really should be two different nations. And the two different nations can have two different Congresses, two different executives, and two different Supreme Courts. And west of the Mississippi, just to make this up because it's not really divided this way, but west of the Mississippi, there's essentially the Western states, and east of the Mississippi is the Eastern states. And they're completely different countries. Like Germany is a country that's separate and distinct from Austria, even though they have a common border. And the argument would be that if you want to be in a liberal part of the country, you go, just to make this analogy, west of the Mississippi. And if you want a more conservative approach, you go to the east of the Mississippi. Now, the Mississippi.
This brings up a question you touched on about 20 minutes ago, which is should we not have a structural reformation of the Constitution so as to obviate some of these problems? Well, and the answer is yeah, we should, but we're not going to get there. The complaint that's most often made about, or one of the most often made complaints, is the Senate does not reflect population at all. Okay. Right. And so we have a Senate filibuster based on 21% of the population or something. Right. And that should be changed. Well, should be until you're blue in the face. 14 states are a block, can't prevent an amendment. And if 14 states benefit from the current arrangement, which they do, then forget about that. So let's forget about it. And the same thing is true of any major structural reform.
I would argue that if you did a hypothetical constitutional convention, you would learn a lot about what the actual possibilities are, even without talking about plausibility or probability. But like right now, I think people firmly believe that women should have the right to an abortion. I think 60, 70%, maybe even 80% American adults believe that that's a right that is or should be enshrined into the U.S. Constitution. Now, these 9 justices don't represent that 80%. I'm making this number up, but I think it's a clear majority. I think there are some graphs about this, and that it is something that shouldn't.
Well, there are 3 positions. One is abortion under any circumstances. The other is abortion under no circumstances. And the third is abortion under some circumstances, like a time limit circumstance or the health of the fetus or the mother's circumstance. Mm-hmm. So I don't think any one of those 3, always, never, and sometimes, has a plurality. But sometimes is pretty weak. Sometimes generally means anytime up to 20 or 22 weeks. And they plus the always are a clear majority. Yes.
Right. So that's a better way to put my point. But I'll just say, just generally speaking, we now have kind of a big division in different states. And it does represent kind of this dysfunction. And it plays into a dysfunction within the court itself. And I think that dysfunction will persist for at least probably the next 3 or maybe even 4 elections, because these justices and other federal judges too, and I don't say that they aren't entitled, I think they're entitled, but whether it's a good thing or not, to be making big decisions in your 90s as frailty inevitably occurs right up to the very end, whether that's such a good thing is questionable, because some of these decisions really require some deep thinking and not just the kind of ranting that some of these opinions are projecting.
They may need it, but as we were saying about the reform of the Senate, you may need it, but that does not mean you're going to get it. So question to you, is this a matter of bad personalities? Like Bill, for example, you suggest that he undergo counseling to be nice. That will never happen. He thinks he's so wonderful that people use his shit for air fertilizer, for air freshener, for God's sake. Okay, he's not going to change. But is it just a matter of his crappy personality, or is there something more involved than that, such as we now have the absolute power in the country in default of the legislature?
Yeah, I mean, I agree with you that it's not just a problem of getting some counseling or management consulting or anything else into that body of decision makers. I mean, that court runs almost like a firm, and it's got 9 partners, with the chief justice being like the managing partner, I suppose. And these 9 partners have very strongly held views, and each of them has a cadre of workers under them.
Right?
I mean, probably it's about 100 key people, key decision makers between the 9 partners and the, let's call it 90 something associates plus the various staff. So probably it's 300-400 people in total that are cranking out these decisions, which I think, of course, are too lengthy, as I've said. And ultimately, if you try to look at this as kind of a problem of, you're creating law and you're in the business of creating explanations for law, and you're in the business of providing leadership and guidance to other judges at various levels about how to interpret the law in same or similar or analogous cases. And if you try to describe the issue that way, kind of in a very objective, almost management consulting way, I think what you would conclude is it's almost like the variety of cases is too great for any 9 people to become expert on. And it's almost like it's too great for a country to have a single court. For example, I, for one, think maybe we need a special Supreme Court for just IP cases, because I don't think any of those justices knows much about intellectual property. And I think they do a lot of learning along the way. But I think they would admit, as I think Justice Breyer and a few others have admitted, that they're flummoxed often by some of the issues that they get from the federal circuit, which now is a specialized court, which itself is divided on various important issues in patent and other cases that come to the federal circuit. So as a general proposition, I think there would be a number of things that could be recommended in the context of a constitutional convention that might be worthy of consideration, because the court is not necessarily static. I think a court could be expanded to more than 9 justices. I think historically it has been bigger and smaller in the past, maybe mostly smaller. People have talked about maybe it should be like 15 justices, and maybe there should be some types.
I think there's a serious problem with expanding the court, which is either a Republican or a Democrat will appoint the 6 new justices. And then when that administration is out and the other side gets in, they'll just bang it up to 21. It's endless. I do think that the idea of specialized courts is interesting, and I wonder whether it might be a good idea to start in the Northern District of California, which is the source of many, many IP cases, and see if a separate bench for IP works and how it works.
Well, they arguably did that, although in a very strange way, in Texas, in the Eastern District of Texas. There was a court, I think it's been sort of decapitated to some degree now, but there was essentially a very pro-interested in patent jury trial court in Tyler, Texas, as well as in various other small towns that had small courthouses in the Eastern District of Texas. That became kind of a hotbed for plaintiffs to file cases, and the venue rules were radically reinterpreted to sort of prevent the level of patent filings that have been historically occurring and leading to big jury verdicts in that venue. But it was a more willing bench that wanted to take on more patent cases over time. Now, in fact, the Northern District is viewed as the opposite. It's more of viewed as a defense-oriented bench from an IP point of view. At least that's kind of the current thinking, that the patent rules in the Northern District of California tend to favor defendants over plaintiffs, whereas the way in which it's done in the Eastern District of Texas, or at least historically done there, it's more pro-plaintiff. So I don't know what the right way to do it. I'm sort of more looking at it from an appellate point of view, and ultimately from a Supreme Court point of view, as to where things may have to eventually go. Because I would say any management consultant or series of consultants looking at the problem would say there's too much range of law for any group of 9 partners to imagine that they can get their arms around, even beyond constitutional law, which itself is a pretty big range of law, but all of the various tax statutes, patent statutes, trademark statutes, copyright statutes, all the rules and regulations under those bodies of intellectual property law. Now we have a federal Defend Trade Secrets Act that makes trade secrets subject to statutory federal protection. We have a body of law that's developing there. So it's almost like you could argue that each of those disciplines would justify a separate group of justices. Maybe it would be 3 on a panel, almost like a super court of appeal. Maybe they would be viewed as sort of a higher level court to the federal circuit. I don't know the right answer to it, but I can tell you that I think the human capacity, the capacity of a human brain to be able to absorb and actually be able to give a considered opinion in such a wide range of, call it 100 cases per year, is a challenge, is a real challenge. And I think the cases are getting more complex, and I think the decisions are as a result getting more frazzled. And if that's the right word, they're getting more, I don't want to say shoddy, but they're not at the level that, say, the world was at the 100 years ago, when Holmes and other, lions of the bench thought, a 3-page decision was more than enough for the Supreme Court to give an utterance about a body of constitutional law. 3 to 5-page decision was sufficient to carry the message, whatever that message was. I mean, if you boil down some of these 3 cases to the ultimate message, I think we would say you probably could reduce each of them to 3 to 5 pages, but it would leave out a lot of the detail. But I'm not sure the detail is necessarily helping, except maybe to allow more distinctions to happen in the future. If they want to take the course of the law at a different level, all of that detail is there to allow some differentiation and some distinctions to be drawn in future cases, like if they get the mixed race marriage case.
You're right. They're 10 times longer than they have to be. When I was preparing for this session, I made outlines of the issues in the 3 cases. Each outline is half a page, single-spaced, and I don't feel that I missed anything really crucial. Okay, 1 page should be enough to list the issues, and 3 or 4 should be enough to go into the precedent and come out with an opinion. I agree with you.
Right. It's almost like the word processing equipment has only caused this to be so much easier for the writing to do cutting and pasting and quoting and this, that, and the other thing, that volume is trumping what might otherwise be called, brevity as the soul of wit. And maybe I think it's there fundamentally to allow more flexibility in interpretation and the drawing of distinctions and the like. When you see the level of detail that's added, it's almost like that's designed by design. It's allowing people to see differences. And ultimately, that just means a lot more potential derivative cases can get legally filed under Rule 11 because an extension or clarification of the law or of a different set of facts is permissible. So it doesn't really constrain how people will go forward. In fact, if anything, it more or less welcomes that people go forward in deciding whether their particular case is or isn't something that's going to be subject to a particular holding in the case. But overall, I'm a little worried that it's not going to be very easy for law students to pick all this stuff up. Maybe they can pick it up well enough to pass a bar exam, but can they actually pick it up well enough to actually apply it in real life? I'm not even sure that even the constitutional scholars can do it. Like the tribes of the world that make their business creating case books and treatises on constitutional law in America. I'm not sure what he does with this latest body of decision making, other than to say that it's taken a real turn towards a conservative bent. And it looks like that will probably be true for the foreseeable future.
Well, when you say taking a turn, what is it that's taking a turn? It seems to me that the half a dozen concurrences and the 100-page decisions is of long standing. It seems to me that the growth of the range of issues is a fairly long standing as well. What's really new is the lack of collegiality and the spitball throwing that we see in these decisions. Not everybody does it, but it's a reflection of the partisan nature of the decisions, which in turn is a reflection of the default of political power by Congress and its usurpation, except it's just lying there in the ground. It's not exactly usurping. When you find $1 in the street, pick it up. The fact that Congress has dropped its power and does not act means that the executive and the judiciary are taking over those functions. And this leads to highly partisan frames of mind in both of them. The executive, of course, has always been a political branch, and now the judiciary is one as well.
I do think a result of all this is the electorate is much more aware that voting for a president has big ramifications on what the composition of the Supreme Court could look like, depending on when people retire, die, become disabled, whatever, in terms of vacancies. And that more or less a vote for a particular candidate is a vote for the direction that candidate will take the court. And that direction will be impacted by future appointments. I mean, right now, I'm not sure exactly where things stand with the remaining justices that are there, but the 3 appointees by Trump and the 1 by Biden are fairly young people. And they probably have, on average, north of 3 decades ahead of them.
Yeah. In terms of age, Alito and Thomas are the oldest, and one would expect in the natural course that those 2 seats will be the next up. But when that happens is anyone's guess.
And Roberts is not a perfect.
They're in their mid-70s. Okay, right. I'm in my mid-70s. I'm not retired.
Right, and Roberts is not of great health, I don't think, according to reports. Maybe that's been fixed, but generally speaking, if the result is there's 3 appointees that come up in, say, the next 4 to 8 years, the court could swing liberal again, depending on how well Kagan and Sotomayor age, I suppose, right? I mean, I don't think there's any question that Jackson is young and in good health. So just generally speaking,
or Barrett or Kavanaugh, that's correct. Yeah.
right. So, I mean, generally speaking, the one thing to end on is I think people have become more savvy to the vote for an executive really is, and for a party, really is a vote that affects constitutional law in a way that could well have real life, as Buttigieg said in his little comments in the Washington Post and New York Times, could have big effects on things like gay marriage and the constitutionality of that. And ultimately, would he be married and with children? The ability to adopt children as a married couple, a married gay couple. So, to me, we're probably getting some additional learning to the country that I don't think was appreciated before to the same degree as this series of decisions and this change in the direction of the court has produced. So maybe that's a good thing. And there is a sort of an equilibrium that plays out, albeit over a lengthy period of time.
This is about to start a whole new discussion, but the effect of Roe v. Wade, whether you like the substantive outcome or not, and by the way, when it was on the ballot in California, I supported the right to an abortion, but the effect politically was to politicize every judicial appointment from then on. And whether that's a good effect or a bad effect, I really don't know. Whether politicizing judicial appointments in general is good or bad, I really don't know. But we've got it. We have it. This is the situation.
Right. Hey, thanks, Bob, for coming on. I think it's been an amazing period of time reviewing a lot of law. I think I counted something like 470 pages of these three decisions. And obviously the court decided way more than just these three cases. These just three cases were the ones that they ended the term on. But I really appreciate your input and that you're coming on, and happy 4th of July, although I don't think it's celebrated in your neck of the woods, right?
No, it did have Buddha's birthday last week, though.
Oh, the Buddha's birthday? When was that?
I can't exactly remember. June 18th, something like that, right around the summer solstice.
And what's
and he's now 2,543 years old.
Wow. And they keep track of it, huh?
Oh, yeah.
And it's like a big celebration with food and flowers and everything else and parades.
Yes. Basically, anything that happens in civil society, like you're opening a grocery store, the monks come, 9 of them, and they sit around and make offerings to the monks, and they chant for an hour. And for a while, I didn't get it. I thought, how long is this going to go? But I got into it. It's kind of nice, really. Well, and it's really what provides the social glue to the country.
Yeah, I have to say you're learning a lot, and there's a lot to learn, no question. And at the same time, it seems as though there's probably more cohesion in the society in Laos than there is in the United States right now.
Yeah, so that's not a very high bar to cross.
Right. Well, congratulations to you. Happy birthday to the Buddha, and I guess happy birthday to the United States.
United States, yes. We can all join in that. Great. Okay, I had fun too. Thanks. Let's do it again sometime.
Great. Thanks, Bob. Talk to you later. Professor Robert Acker from a small town in Laos calling in for this great podcast. Thanks, Bob. Talk to you later. Bye-bye.
Bye-bye.
Tune in next time on The Valley Current.